Good morning, Your Honor. James Fox on behalf of the defendant Joshua King. This morning, Mr. King appeals his conviction for cocaine distribution in a related subsequent offender count. The sole question before the court this morning is whether the Commonwealth's use of the narcotics analysis certificate influenced the fact finder and contributed to the verdict. Mr. King submits that it necessarily did influence the fact finder. This was a bench case before Judge Ball. The practice at that time was the courts very heavily relied upon narcotics analysis certificates, and that but for that certificate, the proof would not have been sufficient beyond a reasonable doubt.
Mr. Fox, did the officer, I'm just blocking on his name.
Detective Morrissey, Your Honor.
Detective Morrissey, did he ever use the word, did he ever actually identify it as cocaine as opposed to crack or rocks?
He used the term rocks, which is, I'm sure the courts were as street slang for cocaine base. One of the issues that the defense wants to raise this morning is that all the identification of rocks came from the detective, not from the defendant. And that contrasts with the Casale case that Judge Cordy authored, where the defendant appeared at trial and testified as that she did use heroin. Here, the detective goes into premises, says that he wants to buy 2 rocks for $40, then asks for 2 rocks for $30, meaning 2 cocaine rocks for $30. And according to the detective's testimony, the defendant looks around, asks some questions, pulls out a bag which has a series of smaller bags in it of small white substances, which the detective, mind you, identifies them as rock. So there's no evidence.
But he's an undercover detective dealing with drugs all the time. Why isn't it appropriate for him to give his opinion as to the
I'd say the Rodriguez case, Your Honor. The Rodriguez case, the detective, I think that might have been one of the cases you authored. The detective testifies that there was a white, yellowish hard substance that he believed was cocaine, and this court indicated that that was not sufficient to prove.
May not be sufficient, but it's certainly evidence combined with other evidence, the circumstances of the transaction, the field test, which was not objected to. I don't know. Isn't that enough? I mean, it's enough for sure. Isn't that?
There's circumstantial evidence, other circumstantial evidence. It did appear to be a drug house, and that the Detective Morrissey testified he bought from Apartment 1, Apartment 4, and Apartment 7. And
there was really no challenge by the defendant to the substance at all. The issue was some other dude did it, some other. It
was an identification-based offense. Yeah. That doesn't relieve the Commonwealth of its burden to prove all elements beyond reasonable doubt.
No, it doesn't relieve them of their burden, for sure, but they had a field test. They had testimony of essentially a drug expert on the subject, and you have the circumstances of the sale in which rock was produced.
But here, there's no evidence that distinguishes this substance from something from a counterfeit substance. Now, that was not raised as a defense at trial, and I know that you wrote about that in the Vasquez dissent.
But that's a question of fact, isn't it? Here, the defendant he held himself out as selling crack cocaine.
But it's not evidence sufficiency argument. The question is whether or not the use of the certificate influenced the fact finder. The certificate came in at trial. Did the fact finder use that when she deliberated upon the facts of the case?
Do you think the fact finder would have decided differently had there been no certificate in the same case laid before her? Do you really think she would have decided? Any chance she would have decided?
Take the question a step further than that. Suppose we stopped doing any testing whatsoever.
No, there was testing.
But there was a field test where the detective just testified. I took it back to Brockton Police Station, tested it. It was positive. And Justice Brown.
And there was an analysis as well.
There was an analysis.
That was not admissible.
Now it's not admissible.
No. The analysis was admissible if they had called the witness. So there was. I mean, you're going back to before the. You're going back to trial strategy.
No, it's not an ineffective assistance claim. Melendez-Diaz precludes the use of the certificate, and Vasquez, Commonwealth versus Vasquez from this court reinforces that. So the certificate was improperly admitted. The question on appeal now is whether or not this certificate influenced the fact finder.
Yeah, and I'm asking you, do you think if the certificate were not admitted, there's any chance this case would have been decided differently?
Yes, because beyond a reasonable doubt, again, let's take a look at the evidence here. This is not a marijuana case. You look at the McDonald and Nelson cases where there was testimony from police officers about identifying marijuana, what it looks like, what it smells like. Here, when you have cocaine base, and I'm going I think in the Rodriguez decision, there was some discussion about what cocaine base appears to be. Could it be baking soda? Could it be some other fraudulent substance that was cooked down to appear to be cocaine? The circumstantial against Mr. King, evidence against Mr. King here is that he pulls out this substance which may or may not be cocaine based, and also it is identified as rocks by the detective, and that the detective obtains his telephone number. But it's one thing that's careful to acknowledge here is that The defendant did not offer the telephone number. This is something that the detective solicited for future purchases. So, whether or not it's an accurate telephone number, whether or not the defendant, was this a fraudulent substance or a conviction under, I believe it's section, I'm forgetting the sections right now, but fraudulent substance, I believe, is 32G, as opposed to here 32A for possession or distribution of Class B. The proof is exactly identical for a fraudulent substance here or for Class B. That would not get the Commonwealth beyond its burden of proof beyond a reasonable doubt to maintain a conviction.
Was that an issue at trial?
The issue at trial was an identification-based offense, but as this court, I think it was Commonwealth versus Charles, this court said that the trial tactics do not relieve the Commonwealth of its burden to prove all elements beyond a reasonable doubt. Here, really, the only element is composition, because the allegations are that he did make a sale. So,
but there was no impeachment of the nature of the substance on the grounds that it might be a counterfeit substance.
well, the trial tactics at the time were identification. The defense did not go after the composition. Again, at the time, the lab certificate was coming in. The defense did not attempt to subpoena in the analyst, and that is, as Justice Cordy implied by his line of questioning, that is a tack the defense could have taken. Here,
the defendant could have said, I object to the certificate, and then the Commonwealth could have decided at that point, okay, fine, we'll call.
Pre-Melendez-Diaz.
The Commonwealth could have said, fine, we'll call in the lab analyst. Could have, if you raised it, if it had been a defense, if it had been an issue.
But as I think it was, I'm not sure Arthur Vasquez, but as Vasquez indicated, at that time that defense would have been futile. Verdi was controlling in the Commonwealth. The certificate, I suspect it was produced in discovery, so the defense had that certificate. And we have to recall the trial tactics are not bar exam questions. The trial attorney has to choose his best defenses.
Yes, and your best defense, in light of the fact that the substance tested, forget about the admissibility of the certificate, tested positive for cocaine. The test was positive for cocaine. There's a field test. The police officer is going to testify, I'm an undercover agent. I asked for rocks, and this is what I got, in my opinion. Of course you're not going to raise that as a defense.
Well, but presumably, though, there are things that could come out by the cross-examination of the analyst, meaning...
Well, theoretically,
what were the managerial issues in the lab? Were the contamination issues? Were the pressure to come up with a certain response? It was, all indications were that other parties in the house did sell cocaine. Was this individual also selling cocaine or not? Or was he selling a counterfeit substance? There was not evidence here beyond a reasonable doubt. Could defense counsel have subpoenaed in the analyst and brought him in? He could have. But at that time, again, Verdi was controlling at that time, and as this court detailed in Vasquez, that there was a sea change in the way these cases were handled in the Melendez-Diaz versus Massachusetts coming out of the Supreme Court, and in the area still is very much up in the air right now. Williams versus Illinois is going up next year to the Supreme Court again to handle the issue about surrogate testimony. Bullcoming versus New Mexico came out recently, a DNA case talking about does the analyst have to come in or not. And Bullcoming essentially reinforces the Supreme Court's Melendez-Diaz decision.
There's no question there's error here. The real question is whether it's harmless beyond a reasonable doubt based on the case as it was tried, the evidence as it was introduced.
There's no evidence beyond the field test and the officer.
The expert opinion of the officer who was an undercover.
He didn't give that.
He wasn't introduced as an expert opinion. And this is, I believe, the McDonald case that the Chief Justice authored talked about the police officers on the stand testifying in detail as to what it was a marijuana case. Testifying in detail as to what marijuana appears to be. Again, that was an evidence sufficiency case, so that stands distinct from this case. It was not a certificate case. But here, I think the more apt case might be the Nelson case, where, again, another marijuana case. That was a drug cert case where this court found that even though the officer testified as an expert, it was not sufficient to say that the use of the narcotic certificate did not influence the fact finder.
I appreciate this is not in this record, but it is the case, is it not, that what field testing does is say it's presumptively X?
That's my understanding.
not
The Commonwealth
prove
might be able to more in detail respond to that question, but that's my understanding. There was a case I cited by footnote. I believe it was Nevada's decision where this court cited, it might have been a District of Columbia opinion that described field testing as presumptive.
We have a case, too, that I'm not remembering the name, but we have a case.
I believe there's something more recent. I'm crossing up some of the names right now, Your Honor, but I believe there's something more recent from this panel. And that's an evidentiary weight question, though. If the field test is introduced to trial, what weight should the trial judge accord that? Is that sufficient evidence of composition?
You didn't object to the field testing. You didn't ask for a Lanigan hearing. No one cross-examined on the question of what the field testing did or didn't establish, right?
Trial tactics again, Your Honor. Here we had the certificate coming in, and the defense attorney, one, he had to make some decisions about where to focus his energies. It was a bench trial before Judge Ball. He decided to pursue the identification-based defense. This is not an ineffective assistance claim on appeal. But what the standard is on appeal now is whether this drug cert, whether the fact finder in any likelihood used this and it influenced her verdict.
I take it she doesn't mention it in her decision, and it's not argued by the prosecutor in the closing, and it's not really a contested issue in the case.
Well, again, we go back to whether or not did the judge use that. Was there any other evidence of composition?
But there was.
There
was a field test, and there was a 12-year veteran officer in the narcotics unit who said, I asked for rock cocaine, and he produced a bag of 40 pieces of rock, what appeared to be rock cocaine.
The time and the force is irrelevant. In some of these trials, I've seen bags passed up that purport to be cocaine, and it's a small, hard white substance, and that's.
Let me ask you this: is there a difference in penalty for fraudulent substance?
1 year house of correction maximum, Your Honor.
I see.
And
so,
here, go ahead, Your Honor.
So, could the Commonwealth have charged the defendant with both fraudulent substance and cocaine simultaneously?
It appears from the record there's enough evidence to appear an indictment on that the Commonwealth could have made that charge. The Commonwealth did not elect to pursue that route. There were indictments issued on cocaine distribution, and I think it was marijuana possession, and the marijuana counts were either withdrawn or null process. I'm not quite sure the disposition. They were dismissed before trial, so they didn't proceed on that. But again, the question here is what evidence of composition is there beyond the field testing, beyond the circumstantial evidence? And I'd submit to the court in response to Justice Cordy's line of questions that cocaine base, it's in a plastic bag in this man's pocket. Is there circumstantial evidence that it could be cocaine distribution? There is circumstantial evidence, but is it being charged with residing in a house where others are dealing cocaine? And this court has to look at the practical consequences of its decisions. If this court says that the certificate did not influence the fact finder at all, is the next step, does the Commonwealth even need the testing done at all? Meaning, will this just be an officer?
Well, that's not this case. That's maybe the next case where there's a challenge to field testing or something. That's not this case.
If this court wants to take the next step and say that the certificates are essentially meaningless, that someone at the State Police Crime Lab does some testing, sends a piece of paper in, or now a scientist accompanies that piece of paper, will the Commonwealth take the next step and say, why don't we just have our officers field test these things, and that's it. I put a drop on it, and I'm not quite sure what the steps are for field testing, but my understanding is it's something akin to putting drops on the substance and it reacts a certain way, and that's the positive step there.
Now, at trial, was there any evidence as to what the field test was and how he conducted it?
It was very terse. I believe I cited it in my brief. Essentially what the police officer said was that he took the substance back to the police station, field tested it, it was positive, and then they sent it for testing for court. I'm paraphrasing a bit, but that
was all there was.
There was no discussion.
Yes, he just said positive. He didn't even say positive for what. He just said positive.
Correct, Your Honor. And I guess you can apply from the record that since it's a cocaine case, that's what it came back for. And he was giving some testimony about purchasing rocks. But the court makes a good point there. But even beyond that, Justice Gantz, is that there's no discussion about the steps, like what a field test is, what steps did he do. I know it's kind of boilerplate, but what training did he get? He's been on the force for 12 years, but I suggest to Justice Cordy that it does not appear to be something that you gain expertise over time. You apply the test or you don't apply the test. And what will the Commonwealth do in the future if these certificates mean nothing? And Justice Brown brought this up at the appeals court argument, that will the officers always get on the stand now and say, yeah, I field tested it?
No, that's not the case.
Well, that was Justice Brown's concern.
When there's a challenge to field testing and properly laid out, then we can, they make a judgment on that. And maybe you can request an instruction. There's a million things that could happen. But that's not this case.
In this case is a drug cert case where the question is whether or not that drug cert influenced the fact finder.
Right.
And it's not an evidence sufficiency case, which it would be a substantially weaker case for the defense to bring on appeal. And I suggest to the court that the use of the certificate was available. It was a practice at that time for the court, remember the trial judges, to use these certificates and to weigh them in their deliberations.
Just one last question. I take it that insofar as Detective Marcy was an expert, it was more on the distribution issue, wasn't it? It wasn't on the identity of the substance.
It appears to be. It was very terse. He testified that he's been on the force. He worked undercover. He was just back from injury. The testimony he gave, did appear. He really didn't appear to be used as an expert, quite frankly. I mean, the testimony he gave really was very bearable in terms of what the substance appeared to be. I see my time has expired. Unless the court has any further questions, rest on the briefs. Thank you, Your Honor.
Good morning. May it please the Court, Assistant District Attorney Christine Kigan, Plymouth County District Attorney's Office. Your Honors, the Commonwealth's position in this case is governed by Commonwealth versus Connolly. In Commonwealth versus Connolly, the facts are identical to the facts presented here, except in our case, Commonwealth versus King, we have additional facts that render the certificate harmless beyond a reasonable doubt.
In Connolly, there was a whole long series of involvement between the police and Connolly, right?
There were 2 undercover sales that
They were watching him for 14 months or something. I mean, it was a long time, wasn't it?
there was, but with respect to what was charged, yes, Your Honor, it was a distribution of cocaine, and then there was the larger substance that was found that resulted in a trafficking charge. In the Connolly case, there was testimony regarding field testing for both. The smaller quantity, which created the distribution of Class B, and also that there was a piece of the large chunk that was taken off that resulted in the trafficking charge. This case is governed by Connolly, and Connolly has been reaffirmed by this court in several other decisions, as this court is aware. In Vasquez, in Fluellen, in Rodriguez, and just recently in Nelson. Rodriguez and Nelson, this court noted the absence of field testing in finding something not harmless beyond a reasonable doubt.
Is it Fernandez in which there was field testing?
In Fernandez, there absolutely was field testing. And in Fernandez, it was a jury trial, a distinction. With our case, we had a jury waive trial. It's an important distinction because in Fernandez, there was a jury instruction that was given to the jury that instructed them that the
Was presumptive.
field
correct?
test was presumptive.
And
Thank
isn't
you.
that in fact the case? Isn't it presumptive?
In terms of this particular trial record,
As a general matter, isn't that the case?
as a general matter, it does appear to be. The more I've read on it, yes. But as relates to,
So
again,
we
the
should
facts.
unfairly say that she erroneously assumed that it would mean, of course, it's cocaine? Is that what you're suggesting?
That who should assume?
Judge Ball?
No,
That
Judge
we should
Ball.
assume that Judge Ball assumed this establishes that it's cocaine, I don't need the certificate?
It is presumed that the judge followed the law, and in this jury waive trial. It is presumed that Judge Law only gave that certificate of analysis the weight that she was only required to give it, which is prima facie evidence. And it is also, in this case, with no challenge to the field test, no objection, no motion to strike, no Doe-Bear-Lanigan request, no challenge whatsoever to the nature of the substance itself. It's presumed that the judge gave the field tests full probative value, not her outside knowledge of what she may know or might believe to be the presumptive value of a field test. There was no evidence of that.
So you're saying if if this were a jury trial, we would have a different result? Is that what you're suggesting?
If this were a jury trial, no, I don't think there would be a different result. I think that it's one additional factor that weighs in the Commonwealth's favor, in favor of harmlessness on these particular facts. It's not only that Judge Ball had, because as I said, this case is governed by Connolly, but we have more than Connolly. We have the circumstances of the sale here. We have a defendant who is so concerned about the security risks. In this very brief trial, the detective did testify that he was inquisitive, that he wanted to make sure that Detective Morrissey was not a police officer. It is reasonable to infer, and it would be reasonable for Judge Ball as the fact finder or a jury to infer that somebody would only be so wary of selling something that was illegal. That lends in favor of finding that it was, in fact, cocaine that he was selling. In addition to that, you have the testimony of Detective Morrissey that he went looking to buy cocaine. And then he speaks for the rest of the trial in the street slang that he was looking for rocks. He requested the rocks, and in response, the defendant produced the rocks. That is an implicit vouching by the defendant that the substance he's selling is the rock cocaine that's requested.
But in a case involving beat bags, same thing would happen, wouldn't it?
The same kind of conduct would happen in that the detective may ask for, the purchaser would ask for it, the defendant would sell it, but not the earlier circumstances that he's going to be concerned if he's a police officer. He's going to ask what kind of car are you driving, who has sold to you in the past. Those circumstances are critical here because the circumstances of this particular sale are highly relevant in determining what that substance was and what the defendant, he held himself out to be a drug dealer. And and his concerns for security and his concerns about who he was selling to are highly relevant to trying to determine what the nature of that substance was. Standing alone? No, and that's not what I'm suggesting. But it is one additional fact in the harmlessness assessment here.
But don't we have to don't we have to ask ourselves whether the evidence of the drug certificate analysis simply contributed to the verdict?
Yes.
I mean, even if it didn't come in, even if they never used the drug certificate, we're not concerned with whether or not the evidence was sufficient to warrant a finding of guilty.
I understand.
We have to satisfy ourselves that this certificate did not contribute to the verdict. Persuade me.
Sure. Well, again, as was held in Connolly, there was no objection, there was no challenge to the field test, and this court found that the field test was sufficient in relation with the other factors. In this particular case, the judge heard, again, the judge is presumed to follow the law and give that certificate the limited value for which it has. You've got a 12-year experienced narcotics detective. He testified that the defendant sold him what appeared to be rocks. And again,
do you agree that the certificate was the strongest piece of evidence in this case?
I do not.
What was the strongest piece of
The
evidence?
circumstances of this sale, along with the field test, because in addition to the defendant's concerns for security measures and producing the rock when requested, the defendant also gave this undercover officer his telephone number for future purchases. And I suggest it doesn't make a difference if the undercover asked for it or if he offered it, because when he gave that phone number, when he gave his phone number, he was putting confidence behind the product he was selling. Drug dealing business is a repetitive trade. It depends on repeat customers in order to be successful at it. It makes sense, it's reasonable to believe that the defendant providing a phone number upon the request from the undercover officer so that they could make future purchases.
So you would say if he was selling a counterfeit substance, he wouldn't have given his phone number?
It's not reasonable to infer that he was selling a counterfeit substance. It's based on all of these circumstances. What's reasonable for the fact finder to infer from this whole chain of circumstances from the beginning of the sale until the end? And sandwiched right in the middle of all of that is the field test.
Do you think that, going forward, do you think the Commonwealth needs to introduce the certificate?
I think that it depends on if there's a challenge.
Facts. Do you think the Commonwealth needs to introduce the certificate?
Needs to, in order to satisfy the burden of proof? I do not. On these facts, I do not. The evidence in this case, I suggest, with these facts is so powerful, so overwhelming, that it nullifies the error in the admission of the certificate. And I would suggest that in this particular case, the added factors, I would suggest they're plus factors to Connolly, are the circumstances regarding the sale. Again, what else is important is that the defense in this case, and I know that there are the cases that say that the defense itself is not the defining line as to whether or not something's harmless, but it's still a factor. And in this case, the defense was not, this isn't drugs. The defense was mistaken ID. The defense attorney said that in his opening, or in his closing, rather. He called this a drug house, and his whole defense was centered on the other sales that the undercover made from inside.
But how, given the certificates, how could he possibly have a defense of this isn't real stuff?
He could, well, he could have any defense. I mean, he's got
I know theoretically, but if you know that the drug certificates are coming in, is there any quantity, I mean, scintilla of rationality to go on a defense if this wasn't really cocaine, it was counterfeit stuff?
Well, I don't know that that's the focus. The focus isn't whether that would have been a rational defense. The focus is that did he challenge it? Was it challenged? And no, it wasn't challenged. And where does that bring us? And it's waived. It's not challenged. It wasn't challenged.
Vasquez and says it would be futile?
Futile in terms of challenging it. Vasquez does say that, yes. But in this particular case, the defense attorney didn't challenge the field tests. And if they are as unreliable as the defense attorney has suggested that they are, then it could easily have been a tactic on the part of the defense attorney to waive. He could have probed further, as was noted by Justice Brown in his dissent in this case. He absolutely could have probed further and asked further questions about the field test. It was right there in front of him. He chose not to, because his defense in this case wasn't the nature of the substance. His defense was mistaken identification.
And the problem in the case, it strikes me, but maybe I'm the only one of this view, is that the substance in fact was tested and in fact was cocaine. So the evidentiary question of how that's going to get into evidence is a separate question from the strategic decision that, all right, identification is our defense. We lose on every count, and there's nothing ineffective about that, and therefore you choose not to challenge the field test. You choose not to challenge the testimony of the officer. Those are choices. And the question is whether the certificate, without the certificate, there was not proof beyond a reasonable doubt.
No, that's not what you do.
Or whether if the certificate hadn't been admitted, it would have made a difference.
Right. And the focus being, again, the harmlessness. Again, what this case is all about is, yes, it was error to admit the certificate, but was it harmless beyond a reasonable doubt? And unless Connolly is reversed, the facts in this case, as I said, mirror that in Connolly, and we have additional facts. Under Connolly, under Vasquez, under Flewellen, under Rodriguez and Nelson, noting the absence of field tests, the facts in this case, the circumstances of this case, demonstrate that the admission of their certificate was harmless beyond a reasonable doubt.
Let me ask you, did we give undue weight in Connolly to what you agree is a presumptive test?
Again, just so that we're clear, I've read some materials about it being a presumptive test until, as was discussed earlier, there is a case that really puts it out there and challenges and brings forth evidence from both sides, not just the defendant's side saying that it is a presumptive test, but let's hear from the Commonwealth, let's hear from both sides to see what these field tests are all about. No. And that day hasn't come where where it's an issue that's ripe for this court to decide.
Well, there was a field test in Bullcoming, wasn't there?
In Bullcoming, I am not sure if there was.
I thought there was,
don't
and
know
I thought
that.
it was not
Bullcoming
enough.
was blood. It was blood. It wasn't.
It's a blood test, I think.
It was blood.
I think so, wasn't it? I don't think it was
Blood
drugs.
alcohol.
Oh, that's right. Blood alcohol. They drew his blood for
Yes,
blood alcohol.
BAC.
That's what I thought. I wasn't sure. If there are any further questions, I would rest on the brief.
Thank you.
Thank you.
Let's take a break. Yeah.